we are great honored to have Dr. Guo Shuai as our speaker today. And Dr. Guo's topic is about future of Chinese financial stability law. So first, I will give a brief introduction of our today's prestigious speaker. So Dr. Guo looks very young, but he already has a number of prestigious achievements. So currently, Dr. Guo is an assistant professor at the China University of Political Science and Law. He is also a consultant for the International Institute for the Unification of Private Law. So Dr. Guo has authored 3 books and more than 30 journal articles, so very prolific. And Dr. Guo has recognized as the Global Restructuring Review 40 under 40. So without further ado, I'm now handing over the time to Dr. Guo. Yes.
And thank you for the kind introduction invitation, Professor Jinghui. I'm a little young. I like to hear that, but I'm not that young anymore. And today's topic I'd like to share is about resolution liquidation, the future of Chinese financial stability law, which is a project I've been working on for the past few years, also working with the institute I work for, International Institute of Unification of Private Law, Unidroit. So give you a brief introduction of what is this law about and what I'm going to talk about. So since March 2022, during the Lianghui, so our government published a work report always in March about the necessity or the plan to draft a Chinese financial stability law. We call it in Chinese 金融稳定法. And in April 2022, just 1 month later, to our central bank, People's Bank of China, delivered a first draft. And at the end of that year, December 2022, our National People's Congress, the legislative body at national level, published the first draft for public consultation. And the second consultation was released just a couple months ago in June 2024, also by the National People's Congress. So in between, there's 2023, why there's a gap there? Because in 2023, a major financial reform in China is the reconstruction of the financial regulators, namely the National Financial Regulation Administration. So that's why in between there's nothing done, but still it's among the top priorities for China's legislative body to draft this Chinese financial stability law. Judging from the title, you can know that we are dealing with financial crisis, financial debt problems. As you may hear, there are quite a few instances in not only about the financial institutions, about real estate companies, about other retail import and export companies, as well as our local government debt. So generally, the whole idea behind this financial stability law to make sure that Chinese financial system is resilient enough to able to address all the potential failures and risks. So currently, we have a draft, not a final version. So just a draft with like 6 chapters, general provisions, financial risk prevention, financial risk mitigation, financial risk resolution, legal liabilities, supplementary provisions. And among them, I have highlighted the 3 pillars in Chinese with prevention, 防范, mitigation, 化解, and resolution, 处置, which is the main focus of this financial stability law. Generally, you can see risk prevention, you can understand similar to financial regulation. And that is before any problems happen, there is a regulation to make sure the financial institutions are in good shape. And if there is something weird or something happens, we go to chapter 3, the second pillar about mitigation. Mostly it's about early detection and early intervention measures, authorizing financial regulators to intervene in a timely manner and solve the problems as early as possible and resume the normal business of banks and other financial institutions into back to normal. And lastly, and also third pillar is about financial risk resolution, which is also what you might have known or what is being discussed at the national level about bank resolution or financial institution resolution, which authorizes financial regulators, especially resolution authority, to step in to address the financial failures if there is not enough room for like prevention or mitigation. So basically, at this time, there could be several very extreme measures taken by financial resolution authorities. I think I have it here. I will explain a little bit more about what the resolution framework is during in this slide. So basically, for financial institution failures, there are like at least two types of instruments promoted by international organizations. One is on the left side, is promoted by the Financial Stability Board, FSB. And on the other side is the institute I work for, International Institute for Unification of Private Law, Unidroit. As you can see from the title of the two institutions, Financial Stability Board is mostly about financial regulation. So it's more public authority-oriented way of resolving the failures of financial institutions. On the other side, Unidroit, judging from the name, International Institute for Unification of Private Law, it's a private law mechanism to address financial institution failures. So you can see from the instrument title, FSB has its key attributes, effective resolution regimes for financial institutions, while Unidroit is still a draft. So we are working on that. We are having the final meeting in November in Rome, which is where Unidroit is seated, and FSB is seated in Basel. But on the draft legislative guide on bank liquidation. So there's more. So when you think about liquidation, you think about the courts. So that's a general idea of courts and also other authorities to go into like insolvency or bankruptcy proceedings. While on the left side, the resolution regime is allowing financial authorities, especially resolution authority, to step in the operations of normal financial institutions. While we think about the normal business operations of a bank or other kind of financial institutions, it's the directors, the board directors, the shareholder decide what they're going to do with their business, with their assets, liabilities. While in resolution, the situation will going to change. While financial regulators and financial resolution authorities would decide what kind of operations the financial institutions are going to take, what kind of measures they're going to take with regard to assets and liabilities, without need to obtain the consent from shareholders, which is a very different, distinct concept introduced by the FSB since the financial crisis, actually. So the first key attributes was released in 2011, 13 years ago, and updated in 2014, while the Unidroit legislative guide on bank liquidation is now still in the legislative process. So a little bit also more background about the scope and authorities. So for the FSB, key attributes on the left side is aimed at systematic important financial institutions. You can understand it in general as very large, big banks. For example, the Bank of China, you must have heard of it, the Industrial and Commercial Bank of China, etc. things. Also in China, there is the Construction Bank of China and China Agriculture Bank, sort of big four, all among the systematic important banks. And the reason why the FSB is targeting these sci-fis is because these financial institutions' failures could trigger large financial crisis, like contagion effect. And that's why the FSB, after 2008 financial crisis, introduced this kind of new resolution regime, aiming to resolve the failures of sci-fis, allowing authorities, I have a list here, supervisor and resolution authorities to step in as early as possible to resolve the failures of financial institutions. While on the right side, we see a gap, actually, of smaller banks, which are not subject to like big banks' resolution regime, because resolution regime, as I introduced, is very extreme measure taken by authorities, regulatory authorities, that will very severely impede or harm the interest of private parties, including shareholders and creditors and etc. things. So those are very extreme measures taken by administrative authorities, and that's why they are restricted to sci-fis, like big companies, where the public interest test is made. But for smaller banks or residual banks in resolution means if a bank enters a resolution, we only risk construction is some of its assets and liabilities, but there are some other parts of the banks that are left unattended, and they will normally enter into other liquidation or insolvency proceedings. So I listed here is also the targets of the legislative guide, smaller banks and residual banks in resolution. So we try to fill the gap on an international level, how to address the failures of other financial institutions. Judging from last year, we saw Silicon Valley Bank, SVB. Also, I don't know whether you heard about other situations in China, but also during COVID and in and after COVID, we experienced quite a few smaller banks failures. Not exact bankruptcy, but the banks in distress, especially in Liaoning and Henan provinces. So those are smaller banks, mostly serving like local community. They charge like high interest, but also like make loans to local enterprises. But because during COVID and after it, we are having some economic problems, and the borrowers cannot pay back the money. So that's why those banks were experiencing some financial difficulties. Those are smaller banks, normally not subject to this kind of very extreme resolution mechanism, but we still need something to help them. What we are going to do is what Unidroit is doing on the right side. So for authorities, Unidroit, we also involve supervisory and resolution authorities, but I also list here, and of course, judging from the title liquidation, when you think about liquidation, is also court involved in this regard. However, different from normal companies, financial institutions are always at much bigger state with regard to whole society. First and foremost, it has a very fundamental financial service function to the whole society, which nowadays I think everyone uses banks to do their financial intermediaries, the daily lives you cannot do done without this kind of financial services. And secondly, financial institutions, for example, banks always has like smaller depositors, which we believe that's very important in our society. And if there's anything going on, or even any rumor not going on, what are you going to do? So last year, during the SVB cases, even my American friend just called me, what I'm going to do? Should I just withdraw all the money from the other banks? Even there's one bank, smaller bank that's failing, people would be afraid that something would happen to their own banks, if not to the bank in failure. So that's like normal people. It's reasonable to think about normal people would like to withdraw their money or to make sure their budget is safe. And that's also why banks is different. And thirdly, it's about the banking system also is an intermediary of those central bank monetary policies. So our PBOC, our central bank, would do this kind of repos and other financial instruments, but through commercial banks. So without commercial banks, we cannot actually monitor the whole economic from a macro-prudential level. So that's why banks is so different. And in terms of normal courts, whether courts are competent enough to deal with the bank failures is still a question. So we have discussion actually in China as well about, so probably some of you know, we do have like specialized financial courts in some of the provinces, and those are courts with specialized judges, and they are equipped with the financial knowledge to deal with this kind of thing. So we have discussion about whether courts should be able to monitor the whole process of financial institution failures. And judges made an opinion that they are totally fine with it. They equipped the knowledge and experience. They deal with a lot of financial transaction litigations, and they think they're totally fine with that. But however, there is one problem about the mandates. Of course, they are not daily supervisors. So normally they need information from, as listed here, supervisory and restitution authorities. Even within the department, so I was also talking to, I mentioned there, the deposit insurer, the supervisory authority, the central bank, with the Financial Administration Bureau, and the depositing insurer. A deposit insurer is part of the central bank in China. However, even within the same department, they have difficulties of accessing the information from the supervision department, also the resolution department. Of course, they need to report like to the supervisors, to the higher official about access to this information, let alone courts. So normally courts needs coordination between, I don't know, maybe a higher court with the banking authorities, and that takes time about information sharing. So practically speaking, even though courts, their judges are equipped with the knowledge, experience of financial matters, but practically speaking, they couldn't like in timely gain the access to this kind of financial institution information about when financial institution is addressed, about assets, about non-performing loans, about the ratio of their bad debts, for example. So we could have question mark here about courts. Also, already mentioned a little bit about the conditions of bank failures and public interest. So the conditions are the same for bank failures if we experience a bank failure thing. But in terms of public interest, as I mentioned, resolution is a very extreme measure taken by restitution authority to directly intervene in the private rights. So that's needs a very strong public interest rationale explanation behind of this kind of measures taken. So that's bank failure with public interest. However, with smaller banks, our aim is to address the failure of those smaller banks, that's bank failures. In terms of tools, that's a very interesting part. A very extreme and typical measure proposed by FSB key attributes is number 4, bail-in. This is a very specialized financial term. I try to expand in brief because it's a very technical issue. So basically, you can see on the asset and liability normal is equal, while there is some liabilities of a bank that cannot get back, for example, non-performing loans. If you are getting some lending some money to, for example, real estate companies, and now the real estate company is experiencing financial difficulties and they cannot pay back the money to the bank. So the banks on the liability side, they're falling short. They're lack of liabilities, but they need to pay back the assets. But they still have the so there's a shortage of assets. However, they still need to pay back the depositors, for example, and that's the imbalance of assets liabilities. To make the asset liability balance again, what the resolution regime proposes to do is to ask the shareholders to absorb losses first. So that's called write-down or conversion. You can generally understand that the shareholders' equity rights would be completely wiped out. So that's 0. And there would, if not enough, there would be loss of absorption by senior bondholders. That's like subordinate creditors. So they normally would purchase some bonds or instruments issued by banks, stating a specific provision, stating that under some circumstances of bank failures, upon the authorization of the financial supervisories, their claims will be wiped out or converted into equity to absorb the losses of the banks from their assets. So that's how the idea of bail-in was structured. However, from my experience and interviews with different authorities, I believe bail-in, even though it's very academic appealing because that involves a lot of private and public rights discussions about how and to what extent the public authorities could intervene in this kind of wiping out creditors and shareholders' rights, private rights. In practice, I think that hasn't been widely applied. We saw last year a similar one, but not exactly the same, about cocoa bonds. So in the Credit Suisse crisis, some of the senior bondholders, supplemental creditors, were written off by the authorities. While there's a problem, while the shareholders somewhat was intact, unaffected. So there were also quite a lot of litigations going on by the creditors suing the authorities about whether they have applied this kind of similar mechanism into process or according to the law. So that's similar to bail-in, but not exactly the same. But you can see there's still some debate going on. Well, the most, personally speaking, I believe the first three, sell business, bridge institution, asset separation, would much more be similar to the right side on transfer tools. So basically, if the financial crisis bank is in distress, it must have some good assets and bad assets. What we are trying to do is to sell the assets, liabilities in total to a third bank. Acquirer will be interested in acquiring. First, there are some assets left. Also, a client base, because they will receive more depositors and other investors. Also, about the reputation still left by this kind of the banks in distress. So the regulators would be much more interested in facilitating this kind of transfer tools, finding a third buyer by selling the businesses, the asset and liability to a third acquirer. But during a period of finding acquirer, there could be some circumstances that a new acquirer cannot be found. So there could be a bridge institution that was established, or asset separation of bad and good assets. So that's how about the general works of the resolution regime. I copied this for tools from the EU regulation, but that's something is different among different jurisdictions. However, the general framework, because the idea is more or less similar. And on the right side, we have the transfer tools. What in the US is called the purchase and assumption, P&A. Well, that's, to my understanding, is much more similar to the sale business. Though also the regulators for smaller banks trying to find a third acquirer to take over the business assets and liabilities, and while the residual part will enter into piecemeal liquidation. Well, what is piecemeal liquidation? I'm selling assets piece by piece, judging from the name. What's the difference between the transfer tools? Because transfer tools, you also sell, it's also kind of sell, but it's kind of sell of a package sale, like also the business assets and liabilities as a whole. While piecemeal liquidation is the company, the bank's going to end, to close, while there could be some remaining assets to be sold, but piece by piece. And generally speaking, the value of piecemeal liquidation is normally smaller than transfer tools. That's why we also in the legislative guide propose transfer tools, but we did not ignore piecemeal liquidation. For instance, we heard in our discussions a Brazilian case. While there were also some assets that were left unattended, cannot be sold, they waited like for 20 years until the inflation rises and the other conditions meet. And they finally, after 20 years, used the piecemeal liquidation to serve the purpose of gaining back some of the value of the residual part of the bank. So that's Still, we mention it as an alternative thing, but generally in a very swift condition, transfer tools are what we prefer during this phase. So probably some of you have heard about the Baoshan Bank, the resolution Baoshan, which we consider the first bankruptcy bank in China in 2019, and it goes on for like 2-3 years. And what they did, I would say, is similar, very similar to the transfer tools. What in China we call the receivership. So the banking authorities, including our central bank, the bank regulators, joint issued an announcement to take over the Baoshan Bank, and they are trying to find a buyer. What they did is they find a like actually two. The one is a transfer to like third buyer already existing bank that's called Huishan Bank in Anhui province. They took over all the business asset liabilities of Baoshan Bank outside Inner Mongolia because Baoshan Bank is Baotou Shangyinghang, which is situated in Inner Mongolia, while their main business were located in Inner Mongolia. Well, they couldn't find a very suitable third buyer. So what they did is to establish, it's similar to a bridge institution, but it's now a formal bank. So established a kind of Mongshan, like Inner Mongolia commercial bank, to take over the business assets and liabilities of the Baoshan Bank's leftovers in Inner Mongolia. What they also did with this semi-bridge institution mechanism is the financial regulators issued a banking license very fast to the Inner Mongolia Mongshan commercial bank, Mongshan Bank. Why they did that? Because we all know, like banks, they need a license to operate and provide financial services, and that's very exceptional case in the resolution of Baoshan Bank. Normally, there will take a long process to obtain this kind of operation license for financial institutions, but they make an exception to the Mongshan Bank because they need license to took over the asset and liability, special depositors of the Baoshan Bank, the banking failure, and to continue to provide critical services to those financial service consumers. So that's what they did also in this kind of way. So normally in a resolution, we apply a variety of different tools combined together to serve the purpose of we try to address the bank failures, we try to protect the depositors, and we try to minimize the impact on the whole financial system. So that's the idea behind this kind of mechanisms. And finally, and but not least, is the funding, which is a core issue of the mechanism, because that's where the money is from. So I've been consulted by the banking, deposit insurance, the insurance sector insurance, and the trust sector insurance, like asset management sector. So what they care about, and also what's the core debate in Chinese financial stability law, is about application of this kind of resolution funding or in the liquidation way deposit insurance. Generally, whenever there is a financial crisis of a bank or other financial institutions, there will be this kind of deposit insurance or security insurance or trust insurance kind of thing to step in to pay back immediately the smaller depositors. In China, it's under 500,000 Chinese yuan. And to make sure those smaller investors, depositors, their rights are fully protected. That's the idea. However, during the process, we still need some funding to facilitate this kind of resolution. We need some money to make a transfer, to make sure the acquirer will not gain too much losses. Probably we need some money to set up a bridge institution to help it operate during the process. So that's where resolution funding comes into play. And that's when we are debating still right now about how and when we should use resolution funding or industry funding. Actually, we could also use deposit insurance for resolution purposes. but that's still debatable about under what conditions this kind of funding could be utilized to facilitate the resolution of financial institutions. The core debate behind this kind of use of funding different from this paying back depositors, because that will create some kind of moral hazard, because we all know there were big banks in good shape. Those are banks in taking riskier transactions. And that's when a resolution funding is collected from the industry. There's like a pro rata ratio based on the performance of different banks and other institutions collected from the industry. And they use the money to save, or not save, facilitate resolution of a certain institution, while the good banks, they're also paying money for the bank backs. That's one of the discussions. And the third one is so the resolution funding would provide a like implicit guarantee that even if you fail, the banks will be saved. So that's a mindset that could affect the directors or decision makers of a bank. They had the feeling that they would be saved or be rescued when they like were end up in a very bad situation. So that's also a debate about resolution funding. And the third one, which is very particular to China, of course, resolution funding is managed, for example, deposit insurance managed by our central banks, deposit insurer, which is a separate department of central banks. While the resolution process is managed mostly by the financial regulator, which is a completely different department, but also collaborate with central banks as well as deposit insurer. So deposit insurers, I heard them too. So the management of the deposit insurer should also be accountable for what kind of measures they could take to save and how much and when they should provide funding for the resolution process. But the whole decision is decided by the regulator, not the deposit insurer. So you can see there's an inherent conflict between why I should provide money to you while you make a decision not involving me. So they are also setting up a exchange communication mechanism involving deposit insurers, for example, in this process to make sure their opinions should be heard and respected. So that's also very institutional problem situated now in the discussion of our financial stability law. So yeah, so basically, I think I have covered much of the thing. So from national experience, we have a single track regime where the U.S. Federal Deposit Insurance Corporation, FDIC, oversees the whole all deposit taking institutions, which is very different. So they have administrative receivership, also the deposit insurer, the Federal Deposit Insurance Corporation, FDIC, oversees the liquidation, like administrative liquidation with deposit insurance. While for other non-deposit taking institutions, I think for those who are familiar with financial law, there's Dodd-Frank Act in 2011, allowing also FDIC and financial regulators stepping in non-bank financial intermediaries and other financial institutions, while on the very extreme measures of public interest, while for other smaller non-banks, they are subject to the U.S. bankruptcy code, which is their code of insolvency bankruptcy. Similarly, in the EU, in 2014, they introduced the Bank Recovery and Resolution Directive and a Single Resolution Mechanism regulation. While directive is a directive that needs to transpose the national law, applies across all EU member states, while the Single Resolution Mechanism regulation established the Single Resolution Board as the resolution authority, oversees all the financial institutions in the banking union, which you can see as the Eurozone areas, but that's too technical, I will skip that. And Also, similar to the Dodd-Frank, they need a list here for institutions subject to 3, public interest. For resolution in the EU, they need to fulfill the requirement of public interest. And for those companies do not fulfill the public interest, they will enter into what they call national insolvency law. So basically, I have introduced this already. And the two supply is similar to I introduced. Also, they have a special single resolution fund managed by the single resolution board as a fund to provide funding for the resolution of banks and other investment firms and other things. But they also have national deposit and guarantee schemes, which is their deposit insurer. So I have introduced most. I want to use this slide to demonstrate there is one single track regime. What there's only the authority dealing with the whole process. While dual track regime, there is a resolution authority plus a national insolvency regulator, or a court to deal with the failures or core smaller banks. So back to China, what we have learned from the national experience and what we are discussing right now, we have quite a lot of authorities involved. I have introduced the supervisory authority, the financial regulators, the resolution authority, the financial regulators, and part of the central bank. We have courts, because according to our bankruptcy law, courts should be the authority to manage the liquidation of banks. And we also have fund managing institutions, and it's very complex because we have banks, we have securities, we have trust, we have insurance, and now we are setting a new financial stability fund. So there are quite a lot of authorities involved on a past dependency theory. Currently, also my personal opinion, we should adopt a dual track regime. So dual track regime allows both the administrative authorities and courts involved, because it's practically impossible to exclude courts completely, because our judges have expressed very strong interest in participating in the administration of bank failure. So they cannot be completely included. However, I believe the authorities are in a much better position because they have the first-hand information about how to address financial institution failures. Also, I mentioned before about the funding mechanism and how the funding mechanism, funding management institutions should share information or be involved in the decision-making process of starting a resolution process. So at least here, cooperation is very much needed in this regard. And nowadays, we also have a receivership, which is a financial regulator could step in a failure of a financial institution. We like failing or like to fail or experiencing credit crisis. I think that works well for the moment because we have seen quite a few cases in this regard. We are now introducing the resolution in the financial stability law. What I propose, and also I have been talking to our regulators, we should be limiting the exercise of resolution, because resolution is very strong mechanism intervene in private rights that will ask the shareholder and creditors, supporting creditors to solve the losses. So a public interest test should be stated clearly in the law. However, I think that is still missing, and we are debating about it at the moment, about the same law. And this one is about judicial bankruptcy. Now, under our bankruptcy law, there's a balance sheet test and liquidity test. However, for banks, we should also thinking about other conditions. For example, they fail to meet the regulatory requirements prescribed in Basel 1, 2, 3, etc. things. We have to transpose to those kind of international standards in our national laws. We could say they were involved in financial fraud and were revoked license. There could be other conditions other than the normal company's bankruptcy. So that should also be very clear state in law. And in terms of how to transfer from resolution to bankruptcy, what I propose, and I think some of my colleagues in China also agree, that the regulators should be in the major decision-making position to deal with the failure banks, for example, applying transfer tools. While after the financial safety is guaranteed and most problems are being solved, there could be residual assets and liabilities left over for banks to decide, bankruptcy courts to decide how to deal with the residual part. And there could be quite a lot of private law matters, for example, avoidance or the liabilities of directors. We need to go back to what happened before, but that is not the mandate of restitution or supervisory authority anymore, because that's involved the liabilities of different stakeholders, and that's totally up to the judges to decide. And well, at that stage, I think the judges play a much more important role to balance different interests. Well, before, especially in the early stage, resolution and supervisory authorities are much equipped with knowledge and information. They have the mandate to request information from the banks and financial institutions they supervise. And they can act very swiftly, because in bankruptcy we have like always it took days and months to deal with a case, while in financial regulators normally could act very swiftly. So that's a little different about reciprocal resolution bankruptcy. Now it's like a little bit messy in the current legislative thing, but that's something we're working on right at the moment. Yes, so we also have, this is already being mentioned in our financial stability law about transfer tools mostly, and they also have a one provision on bail-in. Well, I think in like how several lines. Well, in the EU legislation, I believe there's like 3 or 4 pages on how bail-in should be implemented. So that is definitely not enough. Also, we have proposed that the bail-in has not been frequently applied in other jurisdictions, even though it's a very interesting academic debate, but in practice that could involve a lot of problems of bail-in. Well, we also keep the piecemeal liquidation as an option in our enterprise bankruptcy law. So that's some tools we try to keep and try to use in the future financial institution failures. But we are also debating about whether we should adopt a market-oriented, what we call 市场化 mechanism and/or administrative-oriented mechanism directly supervised by those central banks and financial regulators. So that's a debate, what we are trying to do. I believe that we could involve financial regulators in this process, because they have much more power and resources to solve problems. But I would prefer transfer to find a third buyer on the market through market price, and not forcing the financial institutions ended up in kind of situations that administrative authorities pictures. So that's about what kind of tools we could use. And the last one is about funding. So I have already stated about the funding. So we do have sector funding of banks, securities, insurance, trust. Well, they have a lot of concerns about when and how they should use this money, because their leaders, their senior management will be held accountable if they do not manage the fund properly. Well, we are also setting up a new financial stability fund, 金融稳定基金, which is, I think the idea is to serve as a additional mechanism to save public interest and to ensure financial stability when some banks cannot be saved through the sector front, and they need additional funding to support the resolution process of a bank or other financial institutions. What I didn't mention here is there's a lender of last resort from the central bank's money, which is different from what I list here, because both sector funding and resolution funding are collected from the industry. So all the financial institutions involved in these two mechanisms should pay the funding management institution like insurance on pro rata basis, certain kind of amount of money, and this money is used to pay back or save the financial consumers when a certain financial institution fails. While the lender of last resort additional funding by the central government is using the taxpayers' money, which is not relevant to, not completely relevant, I must say, to the financial institution, because those monies are not only collected from the financial industry, but also collected from other industries. Also, we all pay taxes to the thing. And that is, I think we have reached some consensus. We should minimize the usage of those kind of taxpayers' money, like central bank's money, to pay back or save financial institutions. But the discussion is going on about resolution fund, because there are some people express concerns about how to use this kind of fund, on what conditions, because that's a very vague terms, and especially the management, they want to exempt them from liabilities if they in the future then save other institutions by using the resolution fund. So that's one of the conditions we are discussing right now. So basically, I think I have come to the end. Sorry for taking up 45 minutes. I hope I receive some questions and comments. I welcome any other discussion. Thank you very much.
Thank you for your very insightful sharing. I have a question about the single track and dual track regime. I could understand that you said that financial regulators is obviously have better experience in regulating these. They have experience and they have knowledge, but I could also see that about the whether a court should involve. But could you please further elaborate on the exact role of the court, what they are experienced in, and what in which area they have in a better position than the regulators? Apart from what you mentioned, that the judiciary have expressed interest in this. Apart from this, there's some rationale behind. Thank you.
Right. Is it working? Yeah, thank you very much. Thank you for the question. I think I need to elaborate a little bit about. So the single track regime is now mostly seen in the US, while the regulators is the dominant player in this regard. Well, I think most jurisdiction would adopt a dual track regime, because normally we leave the failure of an institution in the hands of courts, of judges. However, only very recently we started to think about it, allowing the authorities stepping at an early stage to resolve the failures to do that. And the banking supervision is also very near, like late thing. So based on the current regime, it's very difficult to moving all the powers of the previous judges to the regulators. So that's why the debate started to emerge about what kind of conditions and the circumstances and the power allocation between courts and the judges. Actually, apart from our new financial stability law, there is a parallel legislative activity. That is our enterprise bankruptcy law listed above, and the bankruptcy lawyers will propose a separate chapter on the financial institutions. And what they did is to oversee the failure of institutions from the very beginning, the start, to the very end, to the liquidation, like they exit the market. So that's in parallel at the moment. So what we are debating is about a power allocation in terms of that way. I personally will propose that may answer your question. The very early stage, we have financial regulators reject some problems. They could ask the bank to change their behaviors, operations, and remove the management or appoint a new management in terms in a commercial way to save or to ask them to resume normal business. If they fail, they will enter into a second stage of resolution. That it would be step in, the bail in, the transfer, find a sale buyer in time, and not apart from the normal business. So not normal business anymore. And after that, it is what I propose. After the resolution process, there could be some residual part that would be left over for liquidation, and that it was also happened in the Baoshan Bank. Maybe I haven't mentioned it. So after the resolution process is done, all the residual part of the Baoshan Bank went into the Beijing Bankruptcy Court and administered by King & Wood 京都律师事务所 for the liquidation part. I think that's where the distribution of asset, remaining assets is the leftovers power of the courts. Also, courts should be able to judging other private law matters that needs a balance in public and private rights. For example, I think I mentioned direct duties. So that will be ongoing lawsuits for whether the directors have violated their due diligence obligations to monitor the business of a bank, or to file a complaint or notify the regulators in time about the failure, potential failure of a bank. That's something I think leave the court decide for some time. Of course, involved the financial regulators. Also about avoidance, because sometimes the banks will have some very strange transactions just 1 or 2 months before the file for bankruptcy. And that's a private law matter of whether those kind of transactions can be set aside and whether the money could be get back. Those kind of private law matters that does not need a very urgent attention by the supervisors. I think that could be in some way determined by the courts. That's my personal opinion. The fact is that's a still huge debate in between the financial lawyers and bankruptcy lawyers about which authority should act in the monitoring process of the bank failures. To my personal experience, I think in reality, the regulators will have a much stronger voice because they are the first one to actually handle that. And they needed approval. The banks need approval from the regulators to file for bankruptcy in the bankruptcy court. So without this approval, there couldn't be this kind of bankruptcy proceeding commenced. So that's leave the judges and courts in a weaker position to actually start the process. And that's my observation.
Yep, very clear. Thank you very much.
Eshe, good presentation. Just one quick question, and that is from the standpoint of non-bank financial institutions, particularly with the establishment of the new financial regulator. How are the processes, how are the discussions around treatment of non-bank financial institutions, and of course, the relationship between the new National Administration on Financial Regulation and the PBOC?
Thank you very much. That's a very good and complex question. With the new financial regulator, they actually is the former banking and insurance corporation regulator. So they are still in charge of the banking industry, the insurance industry, and what we call asset management trust industry, while the security firms are left over for the Securities Commission. So what they are discussing, I think the main focus is still on banks. I think 70% of the financing channels in China still very heavily rely on banks. But for those asset management industries, non-banks financial institutions, actually I happened to be talking to them last month about what they are going to do. They have generally accepted the idea of a resolution. So that's the thing. And they're under normal supervision discussions. I think a core question that arises in non-banks, because their consumers or their investors are mostly high-end persons, because there's a threshold to enter into this business. So different from banks, well, we all can like invest in or have some deposits in that way, like smaller consumers. For those non-bank finance, the entry level is higher. So we had a debate about whether the fund or the saving mechanism should be provided to those like sophisticated investors, because they themselves should be able to bear the risks. And before they make any investments, they should be required more about their knowledge and experience about making a risk, and then they are have more capacity to take the risks, which is different from depositors. And we are also thinking about the size of that sector, and compared to depositors, we still think that's very small. And then we are doing a general rough estimation about if, for example, trust asset management fail, whether they should have very complex implications on the market, general whole, like on last news media coverage. Of course, those rich people will be affected, but we are debating about whether this fund should be used to save those kind of investors. So, but this is still ongoing, and I personally believe that should be separated from the depositors. Thank you.
Okay, thank you. So given the time frame, we can afford another 1 or 2 questions. So any questions? Yes.
Thank you, Professor, for a very insightful sharing with us. I'm Alice from the law faculty as well. So I just want to ask about the governance mechanism, because in one of your slides, you mentioned there were actually at least 4 parties involved, right? The resolution party, the bankruptcy courts, and all this different entities, right? Yeah, so there are many hands actually in the pie, right? So I just wonder if the draft stability law has got any governance structure around that would resolve if there is any competing objectives, because as a former regulator myself in the financial services, our role is to protect the investors, but the courts are actually mostly protecting the creditors.
Yes.
The mandates actually speak very differently. So what's the current status in the draft law? Thank you.
Thank you very much. I think that's very good and a very cool question. We are experiencing some problems right now. In the draft, courts are not mentioned explicitly as the restitution authority, but there is a transition provision in the draft that they should communicate to the courts, and there should be some linkages mechanisms if when the restitution process is finished, they should share the information with the courts. That's where courts is involved. In terms of different resolution authorities, a list here apart from the courts, they are all mentioned as restitution authorities, but there's no clear provision in the draft about the power allocation between those authorities. And generally speaking, as actually they didn't even distinguish between supervisory and restitution authorities, and they didn't even make explicit to the central bank, because central bank is normally in charge of monetary, one of the daily supervision mechanisms. So they mentioned financial regulators plus this kind of financial stability fund management institutions should be in charge or involved in the resolution process. But what is specific power allocation, I think is not there yet. And I guess it's a very sensitive question. I would like to, since you brought this, I would like to mention again, apart from this two, in China, there's a specific scenario where the local authorities, like the local governments, are also involved in this kind of thing. So we have this situation while the failures of bank happened in a local province, and it's requested the local government provide funding to saving this kind of failures. However, the local government normally do not have the authorities, the supervisory authorities in this regard. So there's a disalignment between the supervisory authority, maybe it's their failure of a supervision or other reasons, but the ultimate responsibility, accountability was left over for local governments, because that's a social stability thing. And they are obligated to provide funding or provide human resources to stabilize the situation. While there's this kind of disalignment also being already reflected in the law, but that's still debating about what kind of mechanisms should be established and what kind of communication or information exchange channels should be established between all these kind of institutions.
So the final question, yes.
Okay, thank you. Thank you, Professor. I'm interested in your slide on conditions, right? In the conditions, there is this slide where it's under resolution and you talked about public interest. So what kind of public interest are you thinking of? I mean, can you give us some examples of what you write in terms of what is in the public interest?
Thank you very much. I think that's very difficult for me as well. So I personally believe public interest is something we should take into consideration, but in practice, it's really difficult to implement or interpret. And that's why I propose on the most circumstances, we should not use public interest, only on like very extreme circumstances. Unfortunately, in Chinese practice, we do not experience a very clear interpretation of public interest, but I could give you an example of the the EU formal practice. So in resolving one of the EU banks or banking groups, you can find it on the Single Resolution Board website, and the authority, Single Resolution Authority, interpreted the public interest as a strong impact on the whole market, given the size, the interconnectedness, the complexity, the value, and the potential failure impact on the whole market. So they have listed some criterion to make this assessment, but however, to me, it's still somewhat unclear because they have some cases of using the same determination factors to decide, okay, this could have like a larger impact on the market. And while there are several other, normally smaller cases, their impact will be mostly local and not have a low chance to be spread over other regions or other countries. So they make decision, but that's still on a case by case basis, and it's very difficult to do. And personally believe, and it's very unclear. And of course, we need to work on that term more. Thank you very much.
Okay, so thank you very much. Yeah, we already run out of time. So I'm now officially closing our today's seminar. So thanks everyone for attending Dr. Guo's talk. It's already lunchtime, so have a good lunch. So finally, please join me to put our hands together to show our appreciation for Dr. Guo's talk. Thank you very much.